wabarakatuh. My name is Amir Fikri bin Kamaruddin, and I am from class CRG660, and my metric number is 2018 679 and 798.
Hello dan Assalamualaikum. My name is Muhammad Izzuddin bin Azhar. My metric number is 2018654054. I'm from KAC 220C.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Syakirin bin Jamaluddin. I'm from class KAC 220C and my metric number is 2018-410698.
Hello, my name is Muhammad Akmal bin Azli. I am from KAC 22060. My matrix number is 2018272422.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Zaid bin Suhaimi. I am from group KAC 22060 and my matric number is 2018802162.
Introduction Case 1, Luster Industries Berhad versus Citychem International. Okay, so first, Luster Industries Berhad is an investment company that based in Malaysia, and Luster Sdn Berhad provides its subsidiaries with management services. Okay, it focus on manufacturing, lottery, and other segments of the company. The manufacturing segment manufactures accurate plastic components, sub-assembly, die casting, and accurate work. The lottery segment is running lots. The other segment consists of investment holdings, mining, buildings, and inactive enterprises. It has subsidiary companies including Luster Precision Engineering Sdn Berhad, which is an investment holding company, and also Winco Precision Engineering that based in Malacca, and which is devoting its services to precise and component plastic parts and sub-assemblies. Luster Manufacturing Sdn Berhad is an investment holding company, and Winco Precision Engineering Malacca Berhad. Meanwhile, Citychem International Limited Company operates as an investment holding company. The company was founded in 8 April 2006 and is headquartered in Hong Kong. So, in this case, Luster Industries Berhad versus Citychem International Limited is where a solicitor becomes aware of any irregularities or fraud surrounding instructions from a director of a company, more so when he is aware of a plan by the director together with the several other parties to siphon company's assets. He will be in breach of his stakeholders' duties if he releases the stakeholder monies acting upon the instructions of the said director. In such circumstances, the solicitor ought to make inquiries with the company prior to releasing the stakeholders' monies, failing which the solicitor is not entitled to rely on the Turken rule.
For issues or offence committed, the offences committed in the case Luster Industry Berhad versus Citychem International Limited is the director had breached the fiduciary duties. The director instructs applicant allegedly on behalf of the company to release stakeholder money. Instruction for releasing stakeholder monies were provided as soon as money was deposited with the applicant as stakeholders. It was wrongful release of interested shareholders' money when the director intend to siphon of the company's asset. The possibilities the director is liable or not depend on whether the director act as a trustee of the company's asset, whether the director act in the best interest of the company, when he directs solicitors to release stakeholder monies, and whether the director violates his fiduciary duties by directing the solicitors to release stakeholders' funds. Solicitors will be in breach of his stakeholder duties if he release stakeholder fund with the director's instruction when a solicitor become aware of any irregularity or fraud involving instructions from a company's director.
Analysis article for the case Luster Industries Berhad with CityChem International Limited or is that there are many judges can appoint to the director and all the director, the company director, all the stakeholder will be liable for the all charge because they are all the same intention or the cooperate with others in wrong use asset in company. The stakeholder has made breach of stakeholding and then release amount of money with instruction from the company director to release monies come after monies have deposited with solicitors as a stakeholder where the solicitor was aware of the stakeholding term. The third party proceeding has the right to indemnify to hold the trust monies. The defendant seeking a claim money paid to the third party has been paid to the third party due to respect share sale agreement. The notice has been made by the third party for the payment transaction held that defendant wrongfully and unlawful cause trust monies to the release.
Hi, I'm going to present the status of offence of case 1, which is the case of Luster Industries Berhad versus CityChem International. In this case, the director instructed the solicitors to release stakeholder monies allegedly on behalf of the company. Instruction to release stakeholder funds were issued as soon as money was deposited with the solicitors in the capacity of stakeholders. The directors aimed to drain off the company's asset. Even the director stood in as a trustee of company's asset. The director had not act in the best interest of company when he instructed the solicitors to release stakeholder monies, and also in this case the director breached his fiduciary duties because of wrongful release of stakeholder monies. Since the solicitors released the stakeholder monies under the director's instruction, even the solicitor become aware of any irregularity or fraud involving instruction from a company director. The solicitor have breach of his stakeholder duty.
As a conclusion, we know that the directors may be personally liable if they fail to meet their responsibilities, such as a breach of the director's duties owed to the company, including to account to the company for profits made from transactions where a conflict of interest was present or did not declare an interest as required. In this case, we can see that there are exactly 11 claims made by the Luster Industries Berhad to the defendant. The first one is CityChem International Limited. The second one is Hao Sung Kong. The third one is Yap Yok Chuan. The fourth is Yap Kian Kok, and the fifth defendant is Yu Ding Wei. The claims is for rescission of a contract procured by breach that will result in the party of defendant being put into the original position before they entered into contract. This includes the rescinding party returning benefits enjoyed by the defendant under a contract with the third party that has become void. The plaintiff can also bring a civil suit for the damages that the company suffers. The assessment of damages would therefore include all expenditure incurred reasonably.
So the introduction for the case 2, the case of Kamal Azura Abu Bakar versus KYP Education Sdn Berhad. This alert discusses a recent industrial court decision that explored what amount to insubordinations and examine how the company deal with this matter. This case of Kama Azura Abu Bakar versus KYP Education Sdn Berhad concerns an employee, the claimant, who commenced employment with IKP Education Sdn Berhad, which is the company, on 1st June 2009 as a lecturer with a starting monthly salary of RM3,150. Over the years, she rose in ranks and was eventually promoted as a senior lecturer in January 2016 and appointed as the manager of Multidisciplinary Research Centre, MUREDAC, in April 2015. As a result of this appointment, she received additional allowance and her last June salary was RM6,205. On 9 March 2017, the claimant received a memo instructing her to vacate her room due to the restructuring of the clinic staffing. Then, on 13 March 2017, the claimant was relocated to the company's Taman Gelora campus from 1st April 2017 until further notice and redesignated as a lecturer. She was no longer entitled to the additional allowance she was entitled to while at Muredak. On 23 March 2017, the claimant received a show cause letter requiring her to explain 5 allegations of misconduct and insubordination. On 11 April 2017, the claimant was given another show cause letter on the basis that she had committed another major misconduct when she was declared a bankrupt back in August 2014 and failed to rectify the issue despite financial assistance by the company. The show cause letter were answered by the claimant in her letter dated 12 April 2017, but her explanation was considered unsatisfactory. Subsequently, a notice of domestic inquiry was issued to her whereby 4 charges of misconduct were preferred against the claimant. The DI was held on 25 April 2017.
The offence committed in the case Kama Azura Abu Bakar versus KYP Education Sdn Berhad is found that she is guilty on the 3 of 4 charges. Or as the result, company proceed to dismiss the claimant with immediate. The claimant appealed that the company by the letter but not avail, which lead to file the complaint against company in industrial court and makes a claimant failing to attend meeting as by instruct by the superior. The issue was also exacerbated when the claimant claimed the reason for the absence was due to falling ill, but is discovered by the court to be credible as a documentary evidence show whether her action had embarrassed the company. Another claimant defense is could her acceptance when her attitude has clearly be incompatible with the due or peaceful discharge of her duty to company. Next is make claiming for the failing to complete the research issue by Mosdi. There are many reasons, such as issue the tone of the response by the superior had been shown whether she had displayed in the subordinate behavior and the respect toward her top management, and another issue when she had been remorsed.
Analysis Case 2 Kamazura Abu Bakar versus KYP Education Sdn Berhad. 3 out of 4 charges were found guilty by the DI panel. Consequently, on 28 April 2017, the company immediately rejected the claimant by the letter of 2 May 2017. The complainant appealed the company in vain and brought the company to the Court of Industry. In essence, she complained that the company had oppressed her and that her rejection was unjustified. In other ways, the company contested the justified charges against the DI, which were demonstrated after a fair DI. His dismissal therefore had a reason or a justification. The court decided in favor of the company following a lengthy trial. The court decided mainly on an issue that considered of whether the company could demonstrate or balance of probabilities the allegations of insubordinates and misconduct. The court did not accept the decision by the DI as conclusive but considered all evidence submitted during the course of the DI for the three charges and decided upon the allegations itself. The court concluded that the allegations in the charges were indeed true. They were well balanced and proven. Given the misconduct and insubordination by the claimant, it was with fairness of excuse that the decision to reject the claimant was made. The claim of the plaintiff was therefore rejected. The court held that her willful disobedience to her superior's instructions to attend a meeting and present a blueprint was insubordination. The court cited in support the case of Zainuddin bin Qasim versus John Ceramic Berhad in 2008, which held the following: the right to control employees is a distinguishing feature of a contract of employment. The right to control implies the right to ask the employee what work to do. It is a dominant characteristic in the relationship of employer and employee, which marks off the employee from an independent character. As such, the employee must subject himself to the said control and behave accordingly.
So the status of the offence in case 2 is the claimant was issued with 4 different charges of misconduct and subordination by the company on 17 April 2017 by a notice of domestic inquiry. The domestic inquiry panels had discussed and pronounced that she is guilty on 3 charges out of the 4 charges. From this, they concluded that the company proceeded to dismiss the claimant effected immediately on 28 April 2017. The claimant appealed to the company via a letter dated 2 May 2017, but to no avail, which led her to file the complaint against the company in the industrial court. She complained that she had been oppressed and victimized by the company, and her dismissal was without just cause or excuse. The 3 charges of misconduct and insubordination by the company that she was found guilty are failure to attend a meeting that she was instructed by that she was instructed to attend without satisfaction reason. And the second one is failure to follow her superior's orders or instructions that she was told to complete her task, and also being the third one is declared bankrupt back in August 2014 and failed to rectify the issue despite financial assistance by the company. So after the trials, the court decided in favor of the company. The court did not accept the domestic inquiry's decision as conclusive, but had considered all the evidence shown for the 3 charges.
As a conclusion, the claimant was issued with 4 different charges of misconduct and insubordination by the company on 17 April 2017 by a notice of domestic inquiry. The domestic inquiry panels had discussed and pronounced that she is guilty on 3 charges out of 4. From this, they conclude that the company proceed to dismiss the claimant effected immediately on 28 April 2017. The claimant appealed to the company via a letter dated 2 May 2017, but to no avail, which led her to file the complaint against the company in the industrial court. She complained that she had been oppressed and victims by the company, and her dismissal was without just cause or excuse. The court decided in favor of the company following the proceeding. The court did not accept the DI decision as conclusive but took all the evidence for the three charges into account and reached its own decision on all the allegations. The claimant was rejected because the claimant had misconduct and insubordination. The claim was a cause and a pretext.